I have seen that there are people who have been waiting for 20 years for these invitations, and unfortunately they were not able to secure one. So if you are among the luckier ones who got the invitation, you should not shy away from doing everything to make it a successful application. My name is Sajjad Malik and I'm a business and immigration lawyer in Oakville, Ontario. The purpose of today's video is about the Canadian Parents and Grandparents Sponsorship Program. Now, we'll discuss the people who are able to sponsor their parents, those who are ineligible to submit the applications to sponsor their parents, and then we'll talk about various elements, evidentiary requirements, and what are the basic pitfalls, and then we'll talk about what are the basic mistakes in these applications. These parental or grandparent sponsorship applications are the applications which are submitted together. There are two applications in that package. One is by the sponsor. The second one is by the permanent resident. The sponsor is the Canadian child who has been invited or selected to apply by the IRCC and has now 60 days. Principal applicant are the parents, grandparents, who would also be submitting their permanent resident applications. First element, which I'll talk about, is who can sponsor parents. Now, you have to be a Canadian citizen. So you are a Canadian citizen or a permanent resident or an Indian registered as an Indian in Canada under the Indian Act. So the first requirement is that you should provide the evidence of your citizenship in Canada, which could be in the form of your citizenship certificate, or it could be a valid Canadian passport, which would establish that you are a person who has sponsored these applications and who meets that element. Second, you have to establish the relationship with your parent. Now, in recent years, I came across a case where the sponsor didn't have an evidence to show relationship. There was no birth certificate available, there was no other document, and we had to go take the pain of getting the DNA testing done for both the parent and the child to determine the relationship. So second evidence is to show that you have a bona fide relationship. Now, if they are your grandparents, you have to provide two-step evidence to show your relationship with your parents and then your parents' relationship with your grandparents to establish that you have a relationship with your grandparents. You must be 18 years of age. No one below 18 years of age is able to sponsor parents. Now, one more thing which you have to keep in mind is that you have to show that you are living in Canada. When you will be submitting that application, you would be living in Canada. And your Canadian address, anything which depicts that you are in Canada, that you are residing in Canada, that evidence should also be provided within the application. And lastly, you have to show that you meet the minimum necessary income to sponsor your parents, that you are able to bear all the expenses of your own family, you yourself, your spouse, your dependent children, and then you are also able to bear all the expenses of your parents or grandparents, or if they have any dependents. You have to calculate the family size from that point of view. Like if you're two people, spouses, then you have 4 children, it makes it the number 6. Then you have 2 parents, it brings it to 8. And if you have a sibling, or if they have a dependent on their child on them who is say 10 or 15 years old, then the number goes to 9. So you have to consult the table for the LICO table, the minimum necessary income table, and see whether you are able to meet those requirements, and then you have to bump up the income to 30% in the case of LICO. The government, keeping in view COVID situation, has allowed a little flexibility. In 2020 tax year, you don't have to show an increment of 30% above the LICO, and you could still be good with a lower income as a traditional year. As we discussed earlier, that someone who is sponsoring his parents or her grandparents, that person would be responsible to bear the expenses of the parent or grandparent 20 years. So for 20 years, that person is responsible that he or she is taking care of all expenses of their parents, their maintenance, their day-to-day care, their dental and some basic needs. You sign that undertaking when you're submitting that application. If there's a co-signer, the co-signer also signs that application. Now, during this period, the 20 years after they become PRs, if any of the parents or any of the foreign national who became a PR goes and claims social assistance, then you are still liable for this. If they claim that social assistance during this period, then the principal applicant is liable, and that principal applicant will be asked by the government to pay off the debts. So that's something which you have to keep in mind, that this is a long-term commitment. When you're doing it, then later on you cannot rely on another sibling or a brother or a sister who were there, who were not sponsors. You cannot shift the burden to them that, look, we are equally good children, so they can take up. You are still responsible and you are on the hook for this. So undertakings, you have to understand the concept. You have to understand that you should be able to support your parents or grandparents for all those periods. And if there's, by any unfortunate incident, if they go ahead and they have to claim social assistance, then you will still have to reimburse all that amount to the government of Canada or whichever department it is. There are people who may still not be able to, despite having met the citizenship or PR requirements, despite being 18 years of age, despite having financially good, stable income and money and the tax returns, despite being in Canada. Who are such people who are ineligible to sponsor their parents? These are the people who are bankrupt. These are the people who have been convicted of a crime, or those people who are spending time in a federal penitentiary or jail. They are unable to sponsor parents. If you have previously submitted an application and you signed an undertaking, but you never honored that undertaking, it may be when you submitted your spousal sponsorship application or your parents' application, you were not able to meet the sponsorship requirements, then you could not apply. Any default of immigration loans or alimony or your child support, when you will consult your lawyer, he would make sure that in the initial interviews and initial meetings, they rule out any such potential challenge or issue, including inadmissibility matters on medical or criminal grounds. When you have completed your sponsorship forms, you have led evidence, you have completed submissions, then you work on the permanent residence application. That is an application by the parents. Now, if you have two parents coming in, let's assume, then one becomes the principal applicant, the second one becomes dependent, and if there's another dependent, they are also included in that application. Permanent residence application is like all other permanent residence application under the classes. They require information. They want to look at whether you are meeting all the requirements, whether there's any criminal or medical inadmissibility or some other kind of obstruction in your case. In those cases, those applications are refused as well. And once you have completed all these forms, the sponsorship application, the permanent residence application, then they are submitted together. There's a complete list of other documents which require to be attached to this application, and then that application is submitted. A few common mistakes which people make during these applications, that they sometimes do not choose the most updated versions of application forms, and they are relying on a friend or a contact who submitted such a sponsorship application 3 years back, and they tell them, all right, I have these forms available in my computer, I can email them, you just fill them out and submit. No, you have to take the most updated versions of files. Sometimes it happens in our practice that we are working on a file and it took a few days, a few weeks or months, and then we have completed everything, and just before submission, when we do our quality check, we realize that one form was changed, and then we update that form, and then we have to do all the process. Sometimes the foreign national is abroad, we have to take the effort to take the pain to get it signed once again and upload it in the system. So you have to make sure that you're using the most updated forms. Second, you have to make sure that you are not only using the most updated version of the form, but you're also signing them. You're also dating them as well. I have seen applications in which whole of the application was returned because the form submitted was neither signed nor dated. So you have to make sure that you don't commit these mistakes. Now, aside from these mistakes, you have to make sure that the evidences, sometimes people forget to upload an evidence to show relationship, and they take it for granted that I have written in the application that this is my relationship and I have provided that information, so that is sufficient to establish the relationship. No, it's not. You have to provide the evidence to the immigration authorities which would establish that you are bona fide related to them. And when there's a two-tier involved, that you are doing it for sponsoring your parents, if you attach your parents application, then parents say birth certificate or something, that won't be enough to establish a relationship with the grandparents. So you have to make sure that this is done properly. Another common mistake which people make is that they do not correctly understand, and they do not correctly calculate the minimum necessary income based on their family size. So you have to be very careful, and there is always an option that if you are facing any issue or any challenge, you can always do a limited consultation with a lawyer. If you don't want to a lawyer or law firm to be engaged in this for a whole application process, then you can go to a lawyer, a barrister, and a solicitor who practices immigration law and go ahead and do and schedule a legal consultation. You may have to pay an amount for that, but then it would be worth it. This is also possible that you complete your application on your own, and then before submitting it, you schedule a couple of hours with a lawyer to review your application package and to pick up if there are any mistakes. Remember, you don't have to mess up this invitation. This is a very precious invitation, and you should do your best to make it a success. Another few mistakes which one can make: sometimes they are unable to establish the residency. They are unable to establish their citizenship. They go to some panel physician or a physician for medical who is not registered with the IRCC. So if you're not going to a panel physician and you get medical done, that's a common mistake, and then you may suffer because of that, and your medical won't be processed. So all these are very this is a comprehensive area, and you have to understand that in these applications, sometimes you believe that there is certain income which you were earning, but from immigration point of view, from these parent sponsorship point of view, though that income would be excluded from being counted towards the MNI. So we have seen that it occurred. People believed that certain income was included, and they reported that income that they met MNI, and later on they got refusals based on that all right, sir, $70,000 you claimed, but your actual income is $65,000. $5,000 benefit is not actually an income which would contribute to this. So sometimes at a very thin margin, a few hundred or $1,000 less, and because you misunderstood the nature of certain income and you assumed that you met MNI requirement, and you even got the EOI, but ITA after an EOI. But when you proceeded with your application, submitted your application, it came up that you were ineligible under that MNI requirement, or you were not able to meet the element with evidence. So you have to file your tax returns. You have to gather all the documents to establish all these elements and rest of the elements. And I would be very happy to schedule any consultation, or if you have any questions, you can post it on our website. You can send them directly to us, and we'll be very happy to support you. My contact information is noted at the end of this video, and I'll be very happy to support anyone who wishes to engage a consul or lawyer in representing his case before the immigration authorities. Thank you very much, and have a wonderful week ahead.